Fox back with another episode of the award-winning Everything Compliance. Today we have special guest Karen Moore joining us, also joined by Matt Kelly, Karen Woody, Jay Rosen, and Jonathan Marks. Matt, we're going to start with you, then we're going to go to Ms. Woody. Karen Moore is going to bat 3 today, and then clean up Mr. Marks, and Jay Rosen, as always, bringing it home. So, Matt, what do you have for us today?
Tom, to start with a couple of very pressing policy developments coming out of Washington within the next show that I will probably touch in internal audit officers quite a bit. What is happening is that next week on Wednesday, March, the Securities and Exchange Commission will finally, at long last, after 2 years, they're going to vote on their climate change disclosure rule. People might remember that they first annulled their proposed climate change rule in March of 2022. It was the longest proposal ever in the agency. I think it clocked in at 400 pages. Become the most commented upon proposed SEC history, which last time I checked was in counting. But the interest here is that the final rule might actually look like. Originally, the SEC had proposed mandatory disclosure of your scope the emission scope 2, which is carbon emissions generated by the power and electricity that you purchase, utility. And then the real meddlesome part had been the scope 3 emissions, carbon emissions generated by your supply chain, upstream, and then your customers. For example, look at a car. The most of the carbon emissions from a car, according to study this, about 70% of all the carbon emissions come from downstream out of the tailpipe. Actually, so there's been a lot of discussion about what these scope 3 emissions will or won't be in the final rule. Rumor is the SEC has now dropped its scope 3 requirements entirely. We do not know if that is true, but thinking had been that if they included scope 3, that various corporate interests haul the SEC in the court to say you can't do that with this rule. I am willing to bet my mortgage payment that no matter what the SEC does with climate change, there are going to be interests who haul them into court to say you can't do this with the rule. But this is also where it gets even more interesting, is that now that word has leaked that they might drop scope 3 emissions. Now the environmental groups are saying they are going to haul the court and say, no, you can't do that rule back in. So we might very well see a scenario that environmental groups and corporate group will both wind up suing the SEC being unhappy with this rule. I actually think the more interesting angle here is also for compliance officers and internal auditors. How are you going to get assurances around this disclosure? Because that is ultimately going to be in an SEC filing. And if you screw it up, you could potentially face SEC enforcement or lawsuits. So regardless of whether it's scope 1 or scope 2 or scope 3 or scope whatever, you need assurance processes in your company to figure that out. And I think that is one of the great challenges and questions about this rule. Then aside from the Securities and Exchange Commission, for instance, we have a second major proposal that is coming up for more debate next week. The Public Company Accounting Oversight Board, the PCAOB, which regulates audit firms. They are going to have a roundtable and reopened the public comment period on the same day, March 6th, have a roundtable discussion about their NOCLAR rule, which stands for non-compliance with laws and regulations. This is something where the PCAOB had proposed a year that will now require audit firms to look much more aggressively for compliance violations at their client companies. And then if they find them, they have to go and report that to the board the way. And there's a lot of people who think that this is going to be a big, hairy mess. how would a audit firm actually understand what a material compliance risk is? Because you therefore would have to know what all the compliance risks are for your company. So that is a dramatic increase in the scope of your risk assessment. What if an assessment of a material compliance risk different from the compliance officer? How are you supposed to settle that? You might see something like a dramatic expansion of the audit fees to get these audits done. But if they are not material compliance violations, then is the juice squeezed? So we have no idea what these questions are yet, but PCAOB is now going to hold a roundtable with whom I'm not exactly sure. They haven't announced that yet, to debate these issues. But the other one where companies and internal auditors really have to think about what is Washington and how am I supposed to build a response capability to whatever is coming down the road. And both of these ideas, I'm in favor of talking more about climate change. I am in favor of audit firms thinking about violations that might cost investors a lot of money. They are noble in theory, but in practice, they are going to be quite difficult to implement. And yet they are with action suddenly coming very quickly of those fronts. We're not going to final vote on no-CLAR soon, but clearly the PCAOB is trying to figure out how to get that. And the SEC, they're going to do on climate change, and they're going to do it within days at long last. So we have a very busy frontier on the public policy initiatives.
Mr. Barks, you have any comments for us?
No, I was just, all of this, it goes back to fundamentally a lot of the things that are happening. Matt's mentioning some great topics, but, if we rewind this a little bit and go back to the FTX and Theranos and Solar Winds, they're all examples of disclosure fraud. So I'm just wondering, what's going to happen as a result of all of this stuff. And, to Matt's point, how do you get your arms all around it is going to be a real issue. Audit fees are already sensitive to begin with. Trying to expand on that is probably going to send a little bit of a ripple effect. So my advice is buckle up and let's see what happens. But it's going to be interesting, and it's going to really, from an overall audit perspective, I haven't even really thought through that quite yet. But the obligation that this puts on the external auditor might be interesting as well.
Well, Jonathan, I think that you pick up on a great point that I think where the PCAOB is trying to go is there are a lot of incidents, unwanted events that can really damage an investor, but they don't involve financial years. And because we had Sarbanes-Oxley come before compliance was mainstream, before cybersecurity was so widespread, we have grown up with internal control overweighted in the finance and accounting functions, but not in compliance, cybersecurity, privacy, various. And I think if we could have gone back in time and look, this is not at all want the situation to look like by 2024. And now the PCAOB is trying to figure this out. But, if you have something like Wells Fargo, where compliance failures everywhere, but strong financial reporting, so there was no restatements, so auditors never really flagged it, not a sensible for the modern investor. But where you could go with audit standards and internal reporting makes no sense. So they're not wrong to figure this out. I just don't know that we've got the right.
Karen Woody, do you have a question?
Well, I was going to piggyback on, I think, this discussion in some sense. And that is just that this is all maybe going to come down to sort of Vice Chancellor Lester or McCormick, or this is just going to be determined through the courts, I would assume at this point. This will get refined by litigation. Really, that's my question. That's my assumption, but I have a question. That was sort of the question I wanted to pose to you, Matt, of just like, how does this get hammered out with any nuance that we can have some guidelines to your point of what is an assurance? Are we just going to wait for a jurist to decide that for us?
Karen, you're better at securities law than me, but I could sketch out a scenario where jurists sue the SEC to knock down, and maybe they try and do it in some other district in Washington, like they do it, say, in Texas or something, where they have very conservative judges. Environmentalist groups, different district to enforce the Scope 3 emissions. What if you get different judges reaching different results? Throughout all of this, we still have the fact that California is going to impose carbon emission disclosure on large companies in months. Europe is also going to do it within 18 months. For some large companies, I think the per question to all of this is, who cares what he does? I've got other obligations already. I can't not do this anymore. It's this really big bureaucrat.
Mr. Marks, I'm sorry I cut you off. You want to follow up?
No, I'm used to getting cut off. Thank you for that, Tom. It's so kind of you. But I think my colleagues and my friends on this call, they picked up for me. So I appreciate that. Professor Woody, much appreciated.
Well, Matt, I would just echo your last point, because this week in the Financial Times, Gillian Tett wrote a op-ed piece that the green audit's coming. And her point was that businesses are driving these issues and these questions. And it really doesn't matter what the SEC says or does. Europe is going to move, California is going to move, but more importantly, the business community is moving because they see it in their interest to know that the answers to those questions. Karen Woody, I asked you to talk about SPACs, not knowing you were going to deliver to us a 17-page article on SPACs this week. So I don't know if my timing was propitious or you're just an incredible content machine.
No,
but
that's an older one, but it just is slowly getting churned out, all this kind of thing. Yeah, but let's talk SPACs, Tom.
So what's going on with SPACs?
Yeah, so SPACs, for those of our listeners who maybe aren't aware of what SPACs are, or why we would talk about them. SPACs are special purpose acquisition companies that are essentially a way to go public without doing the IPO process. And so sort of the quick, high level overview of them is there is what is essentially a blank check or almost a shell company that does go public, that does IPO, and it is nothing. It is an empty company. It's just it's a holding sort of marker on that can be traded. People invest in it. It's an actual IPO. But the terms of that company and the terms of that IPO for just the empty company is that it has typically between 18 months and 24 months, usually 24 months, to merge with a company. And so the way that this works is that is essentially, depending on who you ask, it's a bit of a Trojan horse around doing an IPO, the proper IPO, because there is a private company that does a reverse merger onto the public markets, basically. This empty company merges with a different company that's private. Lo and behold, that company then becomes the publicly traded company through that process. And so a very famous one that I know Tom and I often joke about, and we feel like it keeps coming up over and over, was WeWork. WeWork, famously tried to IPO a couple times, and the SEC kept saying, no, this is not a valid company, because there's sort of a very famous line somewhere in one of the WeWork S1 documents that say, like, we have no ability to actually make money. And so there was a little consternation about why this company was going public. They basically had a couple failed IPOs. And then lo and behold, a few years later, WeWork as a publicly traded company via SPAC. Because, again, there's sort of less regulation. The SEC does some oversight of these things, but it's not the extent that they would do for an IPO. So as you can imagine, especially with something like that WeWork example, there's a lot of concern about potential sort of end around the regulations and around the purpose of these regulations, certainly for investor protection reasons. What is being traded on the markets that's been properly vetted or properly sort of, we've been kicking the tires of what it is that we're allowing to go be traded on our markets. So like I said, there's always a little bit of, there's some problematic issues around SPACs, just ab initio, just through the structure of them. There was a huge pop in SPACs. There was sort of what's called the SPAC craze right about the beginning of COVID, 2020, 2021. And everyone you knew, well, not everyone I knew, but all the celebrities and things where people were making SPACs. So meaning they were going to be the person that had this empty company, and sort of by virtue of their celebrity or whatever it was, there's a famous Trump SPAC, of course, and Bill Ackman had one. There were other people who were famous that were like, just by virtue of me holding this empty company, there's this promise that I'm going to merge and sort of almost Shark Tank, a great company to pull public, and then everyone wins. That's sort of the idea behind it. So, unsurprisingly, there were a number of lawsuits about very fraudulent companies or companies that didn't, the people ended up losing a lot of money in, that had gone public via SPAC. So the SEC started clamping down on their regulations and proposed regulations a couple of years ago that that were finalized in January. That gave a little more that made SPACs look a little bit closer to IPOs. Just one thing is that things like the underwriters who are involved in the initial IPO, so the empty SPAC, have to sometimes stay involved until the merger, just to perform some of the gatekeeping role that underwriters do to make sure, everyone's looking at this with sort of clear eyes about who it is they're merging with. Because there's major pressure to get this merger done in those 2 years, in that time period. The clock is ticking, and everyone kind of loses their money because everyone walks away if the merger doesn't happen within the time frame. So the thing I want to talk about today, just briefly, is there's this great article that just went up on SPAC, on the SPAC notebook, and then got picked up by Kevin LaCroix and the D&O insurance blog. And it's just a great overview of where we have been and where we are going, I think, with SPACs and certainly SPAC lawsuits. It was true that the heyday of SPACs is really 2021. We had almost 200 sort of what's called de-SPAC, and the de-SPAC is basically that merger when the new company takes over. So you had over 200 companies that went public that way. That has been cut almost in half now, I think, because of these tightening up in regulations, and because it turns out a lot of those companies that in that craze ended up being fairly shady. This is Trevor Milton and Nikola. There's, a lot of, for whatever reason, electric vehicle companies went public that way and had a number of issues. And so as a result, there's a number of securities class actions, plaintiffs' lawsuits after the fact. And so this is a great snapshot of how much litigation has been done around SPACs after, by people who had invested and are pretty angry about them and how much money they lost. So the takeaway from this is that I do think we're seeing fewer SPACs because of the tightening of the regulations. The thing that jumped out to me in this sort of overview of seeing fewer SPACs and then also sort of fewer securities related actions about SPACs. There's sort of a smaller universe of people to sue. But one thing I thought was interesting were a few stats they have about how likely it is, depending on which way you go public with your company, for you to be sued. And so they had this sort of projection about this idea that if you have been public for at least 10 companies, for 10 years, those particular companies are only likely to get sued at something about 3%, which again, it's maybe a wild projection. Whereas if you're a recent IPO company, the numbers jumped to about 13% likelihood of getting sued. And it's almost 20% if you've gone public via SPAC. So it's curious how they get to these numbers, but I thought it was a really interesting take on how, you think about the risks and potential litigation risks, certainly, that exists based on what type of company you're working for or working in, anything like that. So I thought it was a great snapshot. I still think we'll see SPACs in play. It's a very interesting and innovative way to go public when, you have resources available that certain companies might not have to go the IPO route. But of course, it's rife with a lot of risk and even a lot of litigation and regulatory risk as well. So shout out to the people who were tracking this, because it's a great article that gives us some overview of this area of the world.
Matt, do you have a comment or question? Oh, Mr. Marks, you have something for us.
No, please go.
I just wanted to say quickly, I hate these contraptions. And Tom, I remember you and I were podcast SPACs 2 or 3 years ago, where I look forward to the fact patterns by 2020, where we have SPAC frauds we're discussing. And lo and behold, just this morning, the SEC brought yet another SPAC fraud charge again on Motors. These things are for companies that are not public, and if you are an investor, it's the most efficient way to flush your money down the toilet. And I have young kids. I have seen how people try to flush money down the toilet. This is even easier than that. They're just rife with fraud. Good riddance to this SPAC bubble. I'm glad it's burst.
Mr. Marks?
I was just going to say, I mean, from an accounting perspective, Matt's right. A lot of these companies just are not ready to go public. I've done a bunch of reverse mergers, even back in the heyday, before they even called them SPACs. And if you don't understand sort of the equity, how old equity becomes new equity, and how the balance sheet and the P&L works out, and all the liabilities, it's a real mess. And so it becomes a very, very technical accounting exercise. There's different ways that these things can transform themselves, either in Form 10 or an S4. And there's different mechanisms. So I know the SEC's always been real skeptical of them, but I'm just wondering how all of these sort of got through, and nobody flailed their arms up before. That's where I'm going with all this.
Well, Karen, let me maybe go a little bit different direction. Do you see a place for SPACs? Realizing that the day you go public, you have all of the public company obligations under Sarbanes-Oxley and all other rules?
Yeah, it's an interesting spot. I do think the SPACs are for the SPAC sponsors. So not for the company that ends up getting merged and pulled public. It's for the people to make a buck on this sort of innovative new way and to get out before they merge with a company that maybe is not ready to go public. And so, from the company side that ends up going public, I would, if I were advising them, I think there's a lot of money to be made in private equity and private space. You maybe give up a little control, but I think there's a reason we have very vibrant private markets before you undertake the burdens and sort of the full public capital markets. So yeah, I don't totally know why people are still agreeing to do it with SPACs if you're the merger, if you're the acquired company, because yeah, it's a lot of risk and then a lot of the burden that comes with being publicly traded.
All right. Well, we're thrilled to be joined today by Karen Moore, who is actually joining us from Puerto Rico. So, reporting from Puerto Rico, Karen, what do you have for us?
Well, it's quite appropriate because I'm looking out at the ocean, and I feel like we've got a rising tide a bit in the whistleblowing area. We're seeing changes, introductions of new legislation, amendments to existing legislation all across the board. And we had the False Claims Act of 2023 introducing some new requirements, Intelligence Authorization Act a couple of years ago, also looking across the board, AML Whistleblower Improvement Act in 2022 at the end of that year. Outside of the US, we have the EU directive, of course, where finally we've got at least 20 of the 27 member states having transposed that law into national legislation, so in 20 different versions of the directive, plus 7 more in the works. There's a Public Interest Disclosure Reform Act in Australia addressing whistleblowers. Dubai Financial Service Authority putting in whistleblower requirements in the DIFC. Even the FCA in the UK is starting to look at non-financial institutions and how whistleblower standards might be implemented there. So with that kind of huge amount of changes, there's more. And I just wanted to focus in on a few. One relatively recent Supreme Court decision, one recent piece of legislation addressing an older Supreme Court legislation, and then something happening in the Southern District of New York as well. So starting with the relatively new Supreme Court decision, there was a unanimous, which is nice for this court decision, in a case brought against UBS by a, now former research strategist. And under SEC rules, and Karen, I'm going to defer to you to correct me, but this research strategist falls under SEC disclosure rules to the extent that he needs to certify that his reports have been independently produced. And he informed his supervisor that he felt that 2 of the heads of the UBS trading desk actually attempted to skew his independent judgment, and he was subsequently terminated and sued on the grounds of retaliatory termination on the part of UBS, which should be protected under Sarbanes-Oxley rules. The Second Circuit was kind of all over the place there. First, the trial court agreed. The Second Circuit held that you need to prove retaliatory intent. And then this quickly at the Supreme Court level became a question of where is the shift in burden of proof. So kind of a subtle but really important decision for compliance officers in looking how to craft their speak up and whistleblowing programs. So the Supreme Court held that in Sarbanes-Oxley actions for retaliatory termination, the plaintiff only needs to demonstrate that the protected activity is a contributing factor in the unfavorable personnel action. And Sotomayor, who wrote the opinion, then goes on to say that the company then has to take the burden of proof to demonstrate that by a clear and convincing evidence that it would have terminated the individual notwithstanding the protected activity. So, I think a really important, first of all, easier to demonstrate retaliatory action under Sarbanes-Oxley, and a real warning message to companies, which is not a new message by any stretch of the imagination, that you have got to keep your HR records really up to date and detailed. You've got to be able to prove I terminated this person because they were a poor performer over time, that there were conversations, that there were assessments, and that notwithstanding this protected activity and subsequent termination, the termination really had absolutely nothing to do with the protected activity. And so I think that's Murray versus UBS, I think is an important but subtle distinction there in shifting burdens of proof for both employees and corporations. Another Supreme Court act, though, that took a kind of a tough position in the ruling in Digital Realty Trust versus Summers. In that 2018 decision, the Supreme Court determined that there's no protection under Sarbanes-Oxley if the misconduct was reported internally rather than to the SEC, which, of course, is extremely problematic, because if you're incentivizing whistleblowers to speak up at all, you really do want them to report internally so that a company has at least an opportunity. The whistleblower can still then go to the SEC. And this really kind of encouraged bypassing internal reporting. And so kudos to both Senators Grassley and Warren in a bipartisan effort to reform Sarbanes-Oxley in this Whistleblower Reform Act at the end of last year, which says, hey, look, you can't do that. So some amendments have made it easier to report internally and still claim protection and incentives under Sarbanes-Oxley. Equally important, though, this Reform Act addresses what's, again, been around for a while, but I think is now just getting a little bit more attention, which is the sort of pretaliation, that you can't stop people or penalize them or financially disincentivize them from going to the SEC by putting in forced arbitration, pre-dispute arbitration agreements in place, saying, hey, look, if you're going to go report something, you have to go through a very costly arbitration process, and therefore you're not going to want to report it. That's kind of on the tail of the JP Morgan interesting SEC enforcement, and kind of not a whistleblowing issue, but dealing with hamstringing customers from reporting misconduct. So we've got the Whistleblower Reform Act really addresses the big questions presented by the Digital Realty Trust decision, making sure that there is at least some opportunity for corporations in their internal Speak Up program to continue to encourage people to speak up internally and not go right to the SEC. And then the third one I wanted to mention is the Southern District of New York, effective just a couple of weeks ago, has put in a pilot voluntary self-disclosure program for individuals, where if you are an individual who is aware of some financial crime or political corruption and feel personally exposed, you can voluntarily self-disclose that and result with some non-prosecution agreement. There are some strings obviously attached to that. You have to fully cooperate, not surprising. It's not available to the CEO or CFO of a corporation. And the one that I really love is you have to have no prior felony conviction or conviction for any other violent crime or fraud in your background. So you have to be a very clean person in order to self-disclose and avail yourself of protection here. I think this is an interesting opportunity because it's an incentive beyond the award, right? There are a lot of awards available from the SEC, CFTC, FinCEN for reporting this kind of misconduct and, get a bounty. Here, here's the personal protection. That's a pretty big incentive if you feel personally exposed that you are at risk. And the challenges for companies now, I think under this program are really, really interesting. You certainly can't indemnify your employees for being indicted. Like, please don't voluntarily self-disclose, even though you may be indicted. It also, I think, complicates some of the company's decisions on voluntary self-disclosure on a corporate level under the corporate enforcement policy. You probably want to try and get ahead of that before the individual. So now it's a known incident to the SEC. So now the individual is not going to qualify because you really, you risk loss of control. I think the key there is you've got to get your potentially implicated employees as soon as you as a corporation are aware of a potential problem and really make them feel backed up, protected. I'm not sure. I think that's going to be an interesting set of challenges. So all of this, everything that's brewing, everything that we're seeing, just re-informs corporate compliance programs. First of all, words matter, in my opinion. The semantics of calling people whistleblowers internally, I think, is problematic because it puts them in this kind of whistleblower regulatory mindset or has that risk. But even more importantly, what are you doing to encourage people to report? How secure do they feel? How protected do they feel? And yet again, what is your anti-retaliation program looking like so that you don't even put people in a position where they feel that they need to go either under Dodd-Frank or Sarbanes-Oxley and start taking action against the company. So whole raft, a whole ocean worth.
Karen, with this, Mr. Marks has raised his hand. Well, I have to acknowledge that.
All right. Well, look, I get the whole whistleblowing thing. I truly do. But if you're going to blow the whistle, especially in a pretty meaty matter, we live in a world where nobody can keep a secret anymore and nothing is sacred. So, it's an interesting play for both the individual who's reporting the ethical violation and the company. And I just wonder if there's a better way. I truly do. I think about this a lot because I know many whistleblowers. I've worked on many whistleblower matters. I've spoken with whistleblowers. Some of them are truly distraught and, in some instances, have some type of PTSD, believe it or not, or depression. And, sitting around at your desk all day wondering who's going to walk through your door or say something, or as you walk out to your car, as you walk out to take the train or the subway home, it's very interesting today. And I just wonder if there's actually a better way of doing this. And so, I'm a big fan of process. I understand the way the process is supposed to work. But Karen, I'm just wondering, what your thoughts are here, because, the reason that people don't say anything really, and that's why I'm a big fan of the exit interview, by the way. I believe when people are walking out the door, there's less fear. I don't think a lot of companies spend a lot of time and effort on actually, massaging that process more and figuring out if there really is something there that they should know. But Karen, I'm just interested, and the rest of my colleagues as well, as your thoughts, because if you're a sole provider for your family and you blow the whistle, and retaliation or not, to go through that process and have to go hire a lawyer and then litigate with the company could be daunting, if not absolutely totally impossible, because you just don't have the financial means to fight the big bear. And again, I just wonder if there's a better way to do this.
Yeah, I mean, I'm with you, Jonathan. Even though the SEC's report on 2023 showed it was a bumper year for informants, I think that they had like 18,000 notices and paid out something like 600 million. First of all, the process is really slow. So if you're the whistleblower and you've lost your job, the process of getting any kind of compensation can be years. And what do you do? But more importantly for me, the part that I find really difficult is if you speak up, and let's, maybe get away from whistleblowing. If you speak up and raise a concern internally, there may not be that hard retaliation, but that soft retaliation, that stress of having betrayed the collective, I think often is almost the worst outcome you can come up with. In my mind, a good company operates a little bit like a club. You're all members of the club, and the minute somebody kind of betrays the club. But I don't have a better way. I do think this links really heavily to the internal investigations process, how well it's conducted, how well people have confidence that if they speak up internally, that a fair process will ensue, that they're protected and even held up as, when I talk to my law school class, I say, is a whistleblower a villain or a hero? Are they betraying the collective, or are they taking an important stance to protect the collective? And I think the company has a lot to do with how that's framed and how that's supported. But I'm also interested in other people's opinions.
Karen, I wanted to ask you, do you see this trend towards, if not honoring and legally approving whistleblowers, some sort of movement for greater speaking up as something that might move towards getting rid of NDAs completely when you leave, or having a lawsuit settled and the settlement be confidential that no one can talk about? Or is it strictly going to be limited to federal or reporting to federal agencies?
Yeah, I think that depends on company culture, and that, moving away from the fear that people are going to talk about their experience. And I think companies have the opportunity to control that narrative, and they fail so often. I'm with Jonathan on the exit interview, talk to people, make them feel heard at least at that point, but talk internally and be reflective, transparent. Don't be so afraid of talking about things that have happened, things that have gone wrong, and what have we done to fix it, or what have we learned from it. So I don't think this is easy. I think the attempts to incentivize external reporting or to encourage this voluntary self-disclosure and self-interest, I find a little bit troublesome. The effort globally to regulate it, navigate it. Those of us who work with the EU, trying to navigate these 27 different versions of the directive, and the kind of hamstringing that goes on there in the efforts to promote fair treatment of whistleblowers, I think is also a huge challenge. So if I sound like I'm all over the place here, I am. It's a complicated one, and one I think that corporations have paid a lot of attention to, but maybe sometimes more lip service than really reflective action.
Well, if you can't be all over the place on everything compliance, you can't be, period. With that, Mr. Marks, what do you have for us this week?
Well, it's a perfect slide into what I'm talking about. So, Karen, thank you for that insight. But thank you to the other colleagues for not speaking up or stating your claim with regards to whistleblowing as well. Appreciate that as well. We'll have a conversation later. But I mean, let's talk about Boeing and the FAA, right? So here, every time I was reading this and I was thinking of the Genesis song "Land of Confusion," playing in the background and listening to Phil Collins. Obviously there's definitely a culture of confusion, and this is not, I just want to tell the audience, we don't mention companies' names because we want to pick on them. We mention these cases because that's the way we learn. We learn from these things, and so I don't have anything against Boeing or anybody else in the world, but I mean, there's some really great takeaways from this investigation that the FAA did. A culture of confusion. Employees actually reported confusion regarding safety procedures and protocols. There's definitely circumvention and override with regards to quality controls and policies and procedures. There's a complete and total disconnect, between senior management and the employees concerning the safety culture. So if you can imagine in an environment like this, where we're just talking about safety, sort of non-financial stuff, Matt, can you imagine what this might look like on the finance side? I don't know. But I looked at this and I said, what can we do better? How can we come out of this, from a governance and a compliance sort of lessons learned? So, obviously, some of the things that we keep preaching about and some of the messes that keep sort of recurring, these recurring themes, clear communication, leadership alignment, proper risk assessments. And I'm going to get to this in a second. Quality control, continuous improvement through feedback. But at the end of the day, isn't it really sometimes about monitoring and making sure that we understand what the risks are and that they're properly monitoring and that we're asking the right questions? And it really does come back up to the board level to some degree, because they're the ones that are supposed to be providing this oversight and this monitoring. So, I asked the question, there may be sort of this culture of confusion, but was the culture of confusion is that really the symptom and not really the root cause? Is the root cause here, which they don't really talk about, the breakdown in governance from a very high level? I think so. That's my opinion. And so, Tom asked me to talk about this week, and I read all of the articles from the various different sources, and I'm looking for this string here where it starts to talk about, governance and what the board should be responsible for. And I really didn't see much of that. Maybe I missed it, but I'm just curious if anybody else picked up on anything else.
Matt, do you have a comment or question?
I do. I'll jump in here because, Jonathan, I think it is, I think you're right that a big part of this has been a long-term drift in governance and strategy at the very tip-top levels of Boeing, where they moved away from being a very strong, unified, centralized company to this very decentralized, and their culture of safety went out the window as that transformation happened. But what really strikes me is I can remember, this was probably 2008. I was having a conversation with an ethics and compliance executive at Boeing, and that was long, but it was certainly very early in that drift. I asked him about employees not really caring to speak up, and he stopped and he said, I understand the importance of strong financial reporting, but I'm from product safety, and if we had employees at Boeing knew that there were product flaws and couldn't really to stop everything, I would want to have that employee skinned alive. And it was a really jar somebody to say. I was comforted by it at the time, but I look now and I see so many people were trying to do that, but then at the top level, they weren't acting on that. They had the raw material of red alerts and fire alerts that they needed to address the culture, and yet the more senior executives, they didn't really reach out, or they didn't really act on that to any. It's something to think about where Boeing now in these last 50 so.
Yeah, and Matt, those are great points. And what Karen was talking about before, Karen Moore was talking about with, sort of this whole gravitation of whistleblowers. I can tell you from an overall practice perspective and kind of being in the weeds here and dealing with a lot of this, that, a lot of times these, the worker bees, sort of the folks that are really doing this stuff every day that have their fingers and their pulse on everything, a lot of times they do levitate that up to management and it dies there. It doesn't go any further. And that's why I think there has to be a better way. I mean, even though there are these anonymous mechanisms, a lot of times these cues are given to these middle level managers and they either don't know what to do with them or they kill them themselves because they don't want this to reverberate up to the top level or some other probably reasons that we've all articulated.
Karen Moore, you have a question or comment for Jonathan?
I do, so many, because Boeing has now replaced Wells Fargo for me as the gift that keeps on giving in terms of lessons learned. But, starting at that board level that Jonathan mentioned, I think some of the best reading is the Chancery Court's decision in denying the motion to dismiss an action against the board members. Really kind of a lengthy chastising of the board for ignoring mission critical for an aircraft company, which has got to be safety, and not establishing communication channels that at least lets the board understand where the concerns are. The thing that stuck with me the most was a quote from an engineer saying, for the first time, I would be afraid to put my family on a Boeing plane. When I talk about really good companies being kind of like clubs where you're part of that collective, to be really loyal to your product in manufacturing is such a huge part of working in a manufacturing company from top to bottom. And to say that you doubt the safety of your product, I think is frightening. In fact, I think a senior manager, former senior engineer was just recently interviewed. I saw something in a newsfeed, and he recently walked off a plane because he purposely did not book a 737 MAX flight, and there was a flight substitution. He got on the plane, realized where he was, and demanded to be let off the plane, which is frightening. So that's that kind of top thing. But also, Jonathan, what you mentioned, which is what's going on the factory floor, where people don't feel empowered to raise a safety concern. That's just the most outrageous. There should be an immediate respect for somebody who highlights a concern. I was talking to somebody recently who's in a manufacturing environment, and he was explaining their yellow alert process, where anyone on the factory floor can raise a yellow alert, which immediately puts a pause and circles the wagon of all the important people needing to make decisions, to take a look at what the concern was, dismiss it as something that isn't actually a concern, or address it. But the person who raises the concern effectively gets, if not a gold star, a pat on the back for raising the concerns, whether or not it resulted in an actual required corrective action. So I think that kind of factory floor culture is critical as what's going on at the board level. And if we want to stop this whistleblowing, it just occurs to me, Jonathan, in terms of finding another pathway, it's that you get people to be listened to before there's something to blow the whistle on. That's really, you create that kind of culture where people feel comfortable speaking up about concerns before they're really concerns.
No, great points.
Mr. Rosen, we had a rare FCPA trial involving Javier Aguilar, a former trader for Vitol Trading. Could you tell us about that and any lessons you may have drawn from it?
Sure, thanks, guys. Javier Aguilar, a former commodities trader for Vitol, had been found guilty of charges stemming from schemes to bribe officials at, get this, the state oil company of Ecuador and Mexico. The verdict followed an 8-week trial before the U.S. District Attorney Eric Vitaliano, and when sentenced, Aguilar could face up to 30 years in prison. A federal jury in Brooklyn, New York on Friday last week, found Aguilar guilty on 3 counts, including a charge of violating the Foreign Corrupt Practices Act and of conspiring to launder money. The Department of Justice opined that today's verdict represents another victory in the office's commitment to rooting out corruption in the international marketplace. The defendant and his co-conspirators sought to enrich themselves through criminal backroom deals. The people of Ecuador and Mexico deserve better, and companies that play by the rules should know that the process is not rigged. A Department of Justice will continue to prioritize holding account individuals who enrich themselves through bribery. The prosecutors allege that Aguilar, a Mexican citizen who worked as a trader for Vitol in Houston from 2015 to 2020, paid bribes to officials in Ecuador via intermediaries. The firm was able to secure a contract to buy about $300 million in fuel from the state-owned Petroecuador, prosecutors said. The bribe scheme continued on, and the officials who were originally bought off were replaced with, get this, new staff prosecutors. And Aguilar concealed the scheme by entering into fake consulting agreements with the bribe intermediaries, prosecutors said. Shell companies in Curacao, Panama, and the Cayman Islands were used to scheme, prosecutors alleged. Aguilar, who was also convicted of laundering money, connected with the bribery scheme involving officials in the subsidiary of Petrobilias Mexicano, Pemex, Mexico's state-owned oil company. The bribes helped Vitol win contracts to supply hundreds of millions of dollars worth of ethane gas to Pemex, and prosecutors said. The evidence at trial included testimony from 10 witnesses, including 3 of the former Mexican and Ecuadorian officials who received bribes from the defendant, as well as consultants who facilitated the bribes and an intermediary who launched the bribes for the defendant, who laundered the bribes for the defendant. Bribe payments were on its ledgers, emails, including from the defendant's alias email accounts, recorded calls and meetings, travel records, and banks records showing how the defendant and co-conspirators moved money through the official channels of offshore companies. In one of the recorded phone calls played at the trial, the defendant told the co-conspirator that his money launderer in Curacao has to make up some of the fake contracts. Aguilar has been charged separately in federal court in Texas over Pemex bribery. Those charges were originally brought in New York, but prosecutors conceded that New York wasn't an appropriate venue. Aguilar faces up to 30 years in prison, prosecutors said, though they haven't indicated the length of the sentence that they might recommend. Vitol in 2020 agreed to pay $163 million to settle bribery, criminal, and civil actions stemming from bids for oil in Brazil, Mexico, and Ecuador. So this is kind of just like an old school case. It's nice to hear about bribing of third parties. And at first, if you bribe, it doesn't work, bribe again. So Tom, did you have any dealing with this company? Were you in the heyday of FCPA Central in Houston?
No, but I've been in a parking lot where shady activities went on. So that's as far as I can go.
You mean you bought those big speakers?
It was 2 alleged World Series tickets.
Oh, okay. I thought it was the big speakers.
So Jay, why on earth would this guy go to trial? I mean, he's looking at 30 years now. Well, probably 15 actually. And I'm sure the DOJ came in at an offer below that. Any thoughts one way or the other?
No, I think it's an interesting question that you bring up, but 30 years, you're right. It's a long time to go. You would think you'd probably drop a dime on somebody and get that reduced by half. So I'm not sure why that hasn't happened just yet.
Well, it continues with our whistleblower theme.
He should have moved to New York.
Yeah. Okay, now on to our fan favorites, shout outs and rants. We'll keep the same order, that being Mr. Kelly, Ms. Woody, Karen Moore batting third, Jonathan Marks, cleanup, Jay Rosen, and I'll follow up. So Matt, you got a shout out or rant for us today?
Well, I do have a shout out, Tom. As much as I would like to rant about a bunch of things, it occurred to me that in our last podcast 2 weeks ago, I was about the sudden news of the death of Alexei Navalny, the Russian dissident who died under mysterious circumstances in a Moscow prison or in a Russian prison. We all know that really Vladimir Putin had him killed. As we are recording this, earlier today was the funeral for Alexei Navalny. And so I'm going to shout out to the many, many thousands of Russians who turned out to pay honor and a debt of gratitude to Mr. Navalny. You can see the video of it all over the internet. It's all over Twitter, where I've been looking at it. And it takes a lot of guts to be able to defy Vlad, who expressly and clearly did not want any big show for Navalny. Well, they did it anyways. And I think there's a certain irony. Before Navalny killed, all of the people who supported him were probably quietly sitting there alone thinking, I agree with him and I don't like him, but I'm just alone. Well, they're all together now, and now they know they are not alone. And now they know Putin is not popular, and we can all see it, and they've all seen it. Delighted to see that this awful thing Putin did has now blown up in his face. So a big shout out to all of the Russians who had the bravery to go and honor Alexei Navalny today.
Karen Woody.
That's hard to follow. I agree entirely with Matt on that one. That's great. I also have a shout out. I'm always usually more pro shout out. This one is actually not related to any entertainment, except actually in some ways it is entertainment, but it's not a TV show this time. My shout out is to the wonderful Caitlin Clark, who is going to make incredible waves in professional basketball career next year. She, of course, is the Iowa basketball player who has revolutionized, it seems, this, and has really transformed in some ways the women's basketball, collegiate basketball, because she has broken record after record and is on track to beat even the men's record for most points scored in a collegiate career. And I know firsthand when Iowa came to play Indiana a couple weeks ago, it was the longest line anyone had ever seen for men or women's basketball game to go just watch this star. So shout out to her, and for, again, just lifting and giving more exposure to women's sports.
Karen Moore.
All right. I don't know if this is a rant or a shout out, actually, but looking at the imminent death knell for the CSDDD, or the Corporate Sustainability Due Diligence Directive in the EU, which already was under attack by some fancy footwork by Germany and Italy. But in a surprise move 2 days ago, France came in and really raised a ruckus that put one nail in the coffin in the European Council vote. It's not very auspiciously scheduled for a final approval by the European Parliament on the Ides of March, March 15th coming up, but I don't suspect we're going to see that pass. We've already got France, Germany, and Italy, and it is a kind of population-based weighted vote. So goodbye to the CSDDD. That's kind of a rave, because I think it's a really onerous provision, but also a rant because I do think that there needs to be something there on the sustainability side, and we'll wait to see what replaces it, I guess.
Mr. Marks, in honor of the baseball season nearly upon us, batting cleanup, what do you have for us?
Well, I'm happy to say I went to the Phillies home opener at Daycare Park in spring training, and they did beat the Yankees. So, I don't know what to say there. There wasn't a lot of people that we all knew in the lineup, but, baseball season is among us. As you well know, I usually rant about things, but this week I'm not going to. I happen to be reading, I don't know what I was reading, but I happen to be reading some news that flashed on my iPhone one morning while I was in one of my insomniatic modes. And there were these two garbage men, you're going to laugh, in the UK. That there was a house fire, and these two guys, one guy jumped through the window 3 times to save, the mother, the father, the kid, or the dog, or whatever. And, the other guy went knocking on doors saying, get out, get out, get out, there's a fire. We hear such bad stuff in this world. And I just read this and I'm like, wow, these two guys were just doing their job, going about their business, and this was going on, and they risked their own lives to save others. So I don't remember their names. I don't remember who they are. I mean, but that story it struck a chord with me, saying, we have to get back to all of this. So that's sort of that's my shout out for the week. And I got one more. It's sort of a little bit self-serving, so I appreciate you bearing with me. I want to shout out to West Virginia University and Dr. Dick Riley for hiring me to teach forensic accounting and fraud in their master's program. It's a great honor to be a part of that institution, and I really, really look forward to being an awesome professor. So, Karen, I sent you some flowers and some candy. I'm hoping you can give me some pointers as I embark on something that is a real passion of mine.
Yep, have fun grading papers. It takes longer than you think.
Mr. Rosen.
So coming to you from sunny Southern California, I'd like to file this one under the rich get richer. So my rant rave goes out to Shohei Ohtani, who signed a $700 million deal with the Dodgers, and then with a little creative accounting, deferred 97% of that money until 2034. So Ohtani's first hit in spring training sailed over the left field porch. So maybe Adam Turtletop will get his wish this year, and the Dodgers might win.
Well, I hate to break up this love fest of shout outs, but I'm going to rant about the U.S. Supreme Court. It took them 14 days to grant cert and Trump's appeal of the denial of his immunity. That means there were 4 votes to overturn that decision. Whether that's the corrupt 2 of Thomas and Sam Alito or the triplet of Trump appointees who Trump has said owes them, of course, it's Kavanaugh and Barrett, we don't know. But there's absolutely no reason under U.S. law, under U.S. common law, under UK law that the U.S. Constitution sits on, or UK common law going back to the Magna Carta to say that a president is above the law. This was a horrendous decision as it could have been, but it's even worse because they are clearly giving Trump rope so that this will never go to trial. If it goes to trial, it's going to be after the 2024 election, so the American people won't know of the criminal activities of Donald Trump. This is just beyond belief. The corruption at the Supreme Court is beyond belief. They are going to literally do everything they can to help Donald Trump. It's not serving the American people. It's not serving the Constitution of the United States, and it's not serving the U.S. Supreme Court. So that's my rant. So I didn't blow a gasket. I thought I would, but I didn't. So that's good. All right, guys, this was great. I can't wait till we come up with when we're together again. And Karen Moore, special shout out. Thanks for joining us.
Thank you so much.